Good morning.
Good morning, Your Honor. I'm Attorney Greg Schubert representing Juan Pablo Alicea. If Your Honors please, as you saw in my brief, the first matter that I'd like to address is the Martin hearing that was held in this particular case. Obviously, in the brief, I have expressed my concern about the decision in Pixley, but I think that there's one thing that we could all agree is that when a motion for a new trial is filed, it shouldn't take 5 years to get a response to the motion for a new trial. I would point out that in this particular case, my primary thrust of argument in this case is that there was ineffective assistance of counsel. And the ineffective assistance of counsel starts relative to the Martin case. At least counsel actually took an objection to not being present, even though obviously the Martin case doesn't lay out that you can be present.
Mr. Schubert, I just want to make sure I've got my facts straight. You suggest that it was the defendant who sought this witness, but both the judge and the Commonwealth assert that it was actually the Commonwealth who was at least introduced the idea of having Mr. Herrera testify. It was not the defendant, and in fact, defense counsel said that testimony would be disaster for his client.
Well, I'm glad that you asked that. I believe, Your Honor, that ADA Moriarty participated in a wonderful ruse by saying that he wanted to grant immunity to this particular witness. As we know, when defense counsel opened, he suggested that obviously Herrera was the shooter. And if Herrera was the shooter, it would have been to his benefit to have been able to cross-examine him. And clearly in this particular case, what becomes important is, if I understand Martin, there is no blanket immunity to be offered to an individual that claims privilege. Privilege is to be extended, if I understood Judge Graney's language, on a particularized question basis. If defense counsel was going to support that his client didn't do the shooting and Herrera was the actual person who did the shooting, and pursuant to the only witnesses that actually testified or had any ability to testify relative to who the shooters were, there were only two people, Herrera and Mr. Alicea.
Are you suggesting, Mr. Schubert, that after a Martin hearing, the witness is called and selectively asserts his privilege or doesn't, question by question, before the jury?
No. And what I'm suggesting is that counsel actually, once he got the ruling, it's important to note that he asked the judge to be present. The judge said, no, you're not going to be present. He then comes back out, and the judge says, if there's something that I find out during the Martin hearing, then I'll disclose it to you. Well, nothing was disclosed to him. What he should have asked was for a voir dire outside the presence of the jury with particularized questions that would have brought forward what was actually a privilege and what would have exposed Herrera as the actual shooter. That's what should have been done. It's probably the major mistake in this particular case and the smartest move that the Commonwealth, in fact, made.
Your contention is that he was the shooter, which would give him a Fifth Amendment grounds by itself.
That's correct. It would. But until we get to that point, the entire trial might have been different had we had at least a voir dire to establish what questions he would have invoked on and what he wouldn't have invoked on, whether he was there. If you get to ask the question of Mr. Herrera, whether he was there or not, is that privileged? I don't think so. And it could have been discovered in a voir dire outside the scope of the jury.
It might well be privileged.
It might all be privileged, but we'll never know because on the record that's involved, the one thing that we do know is that the judge said the only people that are going to be present at this hearing is the lawyer. And I would point out that it is interesting to note that now the Committee for Public Counsel Services mandates that a capital crimes assignment counsel be assigned to someone invoking privilege in a capital case. That wasn't the case here. And obviously, the information that the judge received originally was from the assistant district attorney. And I like to use the characterization that this is a perfect example of the fox being in the henhouse because ADA Moriarty wasn't supposed to be in that hearing.
Well, it started as an immunity hearing.
I don't take it that way as being the start of an immunity hearing because the real truth is when they get to the point, the judge says to him, are you going to call Mr. Herrera? The answer is he said, no, I'm not going to call Mr. Herrera. When you read the facts in this particular case, I would suggest that it is totally beyond any belief whatsoever that the district attorney would have wanted the testimony of Mr. Herrera. That just isn't possible. If we were to apply either a canon or a Zanetti to this particular case, he'd be in big trouble. I agree that perhaps, but what wasn't done here was an examination, and it is at least the claim of Mr. Alicea through his counsel that this Martin hearing was deficient, and because it was deficient, the answer is that it clouds his trial. I don't want to.
So is your point that Mr. Herrera did not have a valid privilege? Is that what you're saying? Because
I'm saying that
that's the ground on which you can challenge it, correct?
What I'm saying is we will never know because the
You've
hearing.
read the whole transcript.
I read the whole transcript, but in my reading of what is actually constitutes a Martin hearing, this did not constitute a Martin hearing.
Well,
and
my point is the judge said he has a valid privilege. Are you challenging that?
I am, because the judge did not inquire into any facts relative to what would actually be a valid disclosure relative to the facts in this shooting.
But the judge wouldn't have even had to have conducted a Martin hearing. He could have just said, based on the representations that were made and the indication from both counsel as to what was going to be the likely testimony in the case, i.e. that Herrera was the shooter in the defendant's view, that based on that alone, there was a valid claim of privilege, and Herrera would not have to set foot on the witness stand.
That's probably true, but that doesn't negate the fact that you can't square that away with the opening statement of defense counsel saying that basically Mr. Herrera is the shooter and not having explored that. And with the Martin hearing that he actually got, and he wasn't informed as to what actually happened at it, it would seem to me that any prudent lawyer in a capital case, there's a reason that we don't, I argue there is no reason to apply a Saffarian standard to lawyers that are assigned to the capital crimes team. We're supposed to be better than the ordinary fallible lawyer. And this negated the defense. This was the first step by the defense that he dropped the ball. And I can only say that it is strange that it took 5 years to get a decision relative to this. And in the decision after 5 years, the trial judge quotes Pixley. And I don't know who's going to examine what happens in Martin hearings if it's only this court, and that appellate lawyers are not allowed to look at what's been impounded relative to a Martin hearing.
Now, in Pixley, it was the defendant who wished to call.
That's correct.
Is there any, on the witness list, did the defendant identify Herrera as a witness for the defense?
I don't think that he had to, because he was already on the witness list relative to the government. And then if you take what I say, you've read the facts in this particular case. I can't imagine that the government would have actually seriously put Mr. Herrera on the stand.
Why?
Because he would have been, at the very least, probably a joint venturer, and it would have been asked, what is the reason that you're testifying here today?
Well, they could, in that scenario, they never could have, because he would have claimed the privilege. Right?
That's correct. But we never, ever reached or found out that, because everything is surrounded in mystery by what actually happened in this particular
But
case.
didn't he have a lawyer that said Mr. Herrera is going to claim the privilege, if he, the Fifth Amendment privilege, if he's called to testify?
That's true, but
Doesn't that, and based on what we know about his potential exposure to criminal prosecution, or the likely exposure to criminal prosecution, that would have been a valid claim, and that would have been the end of the discussion.
I think that the judge has an obligation in a capital case to protect the defendant through the fact of saying, sir, relative to the facts in this particular case and what he would be asked in this particular case, what do you have to put before me that will substantiate a valid privilege in this particular case? Because when he told the defense counsel, when the trial judge told defense counsel, I'll come out and tell you if there's something that really was disclosed at this hearing that's important for the defense, because at least he did object to not being present, so it's not at least reviewable, under a bad standard. So,
but it's the witness's privilege. He doesn't have to make public. All he needs is some likelihood. In fact, the standard is it even favors the witness more than we're focusing on right now.
I agree. And if I can leave the Martin hearing, I've made the argument that I wish to make on the Martin hearing, and if I could just address what other issues, because this case, as far as I'm concerned, is primarily an ineffective case. It's ineffective because the only witness in this particular case, as we know, is an interesting witness. This is a person that consumed 3 bags of heroin within an hour of actually allegedly having the incident and then allegedly identifying him, meaning Mr. Alicea. We know that this witness expressed doubt, that she said to the district attorney, what if I'm wrong? What if he didn't do it? We know that the hospital records in this particular case say that she never ever gave a description or said that she knew who the shooter was, even though she knew Mr. Alicea for over a year. We know that the defense counsel in this case didn't put before the trier of fact any expert to testify as to what this particular person would or would not have been able to discern relative to the intoxication and the drugs that she had ingested. This was a 7-bag-a-day user. She had used 3 within an hour of this incident. She had expressed concerns. We can't really explain why defense counsel waived the suppression hearing relative to the ID, especially when there were only 2 photographs shown to her. Mr. Alicea.
As you said, she did know him.
That's correct, but 2, Mr. Alicea and Herrera.
So 9 and then 2.
Right.
Well, the 2, obviously, as she said in her own things, this tended to focus my attention on who I should actually be identifying. That's her words. It's in the record as that's her words. And he didn't present any evidence relative to that. Relative to the
Right, relative to what?
relative to her intoxication, making it incapable of having her identification being a valid identification. And for the light,
Are you saying before the jury he didn't argue that her credibility was at issue because of her heroin habit, or are you saying that he did not move to suppress her ID?
I'm arguing that he did say in front of the jury that she couldn't, but that he should have had an expert testify for the jury, because the average juror doesn't use 3 bags of heroin within an hour of allegedly examining an event.
Well, didn't he call an EMT to testify to just those kinds of things?
No, the EMT actually was testifying relative to the Glasgow scale, which was really inapplicable here relative to heroin usage. And he should have hired an expert to obviously counteract that testimony also. So there was a double failure relative to the identification procedure. Number 1, not proceeding with it because he had a really reasonable chance. As a trial attorney, how often do you get presented a set of facts like this on a chance to file a suppression hearing on an ID? I would suggest not very often.
Now, there was no motion for a new trial, was there in this case, or am I wrong?
Yes, there was.
Yes, we waited 5 years for the.
Okay, on the issue of the ineffective assistance of counsel, or purely on the Martin issue?
No, I only on the Martin issue primarily, Judge. I had obviously prepared long before this, and I had discovered the Martin issue only after I obtained the ability to read what actually happened at the hearing.
And do we have any proffer from any expert as to what the testimony would have been had the testimony been offered of an expert with regard to Ms. Anderher?
No.
So how can we say that the absence of an expert warrants a new trial when we don't even know what that expert would have said?
As Your Honor is well aware, the difficulty of obtaining an expert for post-conviction relief analysis is extremely difficult. I merely suggest that an expert should have been called to explain to the trier of fact that 3 bags of heroin consumed within an hour is something that would have affected the ability of the witness to identify Mr. Alicea.
Did you seek funds to hire an expert?
I did not. I would point out that I think the counsel dropped the ball when there was the report that allegedly a juror had made up his mind. And I believe that there should have been a voir dire conducted at least of that particular juror or the jurors who made the report to the court officer. And counsel should have insisted upon that and not asked for just a curative instruction strongly given at that point in time. I would suggest that that in and of itself is ineffective assistance of counsel, and it goes further with what hasn't gone on here. I suggest to you that the one thing that we do know is that allegedly the murder weapon in this particular case was a revolver. There were projectiles found, but there were no shell casings found. The one thing that is absolutely true and known by almost everyone is that the record says that there was no gunshot residue on any of the clothing or the hands of Mr. Alicea. There should have been an expert hired relative to that to prove it. It's sort of simple ballistics that a revolver leaves halos on the cylinder of the gun, which is gunshot residue. The gunshot residue comes out of a revolver much more so than it does in a semi-automatic. It was interesting that the trial judge asked whether or not, because he understood the problem that existed there too, because when they pointed out that Mr. Herrera had outstanding gun charges, he said, "Oh my God, I hope it's not a 38. And actually then it was a 25, and he actually asked the question was, could a 25 caliber gun fire a 38 caliber shell, which did demonstrate that there was some question as to whether or not either the court or the average juror would understand the ballistics and the significance. And I point out that somebody on the jury probably understood the significance of the lack of residue, since they actually asked a question about the fact of the residue. So that was obviously in the minds of the jurors at that point in time. So I suggest to you that during this trial, counsel was totally ineffective. From the point in time when he's trying to tell him that Herrera did it, but he did nothing to actually protect Mr. Alicea's rights relative to finding and getting to the position of at least getting something into the record that might substantiate that Mr. Herrera did it. He didn't hire an expert relative to the intoxication. He didn't hire an expert to conflict with the Glasgow opinion. He didn't hire an expert relative to contradict Prazik. And so when you view all of those, this is a massive drop of the ball. This rivals the Diane Farley 1 case, at least in the opinion of counsel, and makes that argument to you. I would say that in my brief, I have obviously argued the position on the ABDW and the polling of the jury, and I have also argued the issue of whether a single gunshot wound can constitute extreme atrocity and cruelty. Unless there's questions from any member of the court on those particular two issues, I would rest on
I would
what
just, you argue differently, but at this point, would you agree that with respect to the ABDW, it is not the substantial likelihood standard, but a substantial risk standard, since it's not the murder?
Yes, I would agree to that. And I'm resting on, obviously, what I had written in my brief relative to those particular issues in this particular case. Unless there's any other questions from the court relative to my claims of ineffective assistance of counsel and the deficiency that I find it and hope that the court would adopt relative to the Martin hearing.
Thank you, counsel.
Thank you, Your Honor.
Good morning, Your Honors. May it please the court, Stephen Carley for the Commonwealth Assistant District Attorney from Worcester County. Mr. Alicea was lawfully and properly convicted of both murder in the first degree for the killing of Hylas Strange and of assault and battery with a dangerous weapon against the second victim, Larissa Andijar.
With regard to that, what do we do? I mean, let me step back. Has anybody gone back to the tape recording or whatever that the court reporter may have and look to see whether that juror said not guilty or guilty? Is this a typo, or do we have a juror actually saying not guilty when polled and nobody stops and says we need to address this?
The short answer is, Your Honor, we have no idea. And the reason is that this was not raised in the motion for new trial, which defense counsel had literally years to raise. The first time this issue ever came up, raised by the defendant, was in the defendant's appellate brief. So we have no opportunity for findings by Judge Locke, who also considered
but
the
you
motion
could have
for new
gone
trial.
back to the, I mean, is there a tape recording of the?
I'm not aware at this point, Your Honor. This is almost a 10-year-old, not quite a 10-year-old conviction. It's a 10-year-old indictment and almost 8-year-old conviction. I'm not certain about the status of the tapes. However, this was only raised at the point of the appellate brief, and so even though the motion for new trial itself was filed and considered for a long period of time, over a year, this issue was not raised, and all the fact-finding opportunities to give to Judge Locke to test his memory, to go back to the tapes, to allow the Commonwealth to marshal evidence in support of a unanimous verdict, that opportunity was lost when this issue was raised for the first time on appeal. So in regards to, I will address the Martin hearing or the so-called Martin hearing briefly in a moment, but if I could just clarify the record. Justice Gantz, you asked whether the ineffective assistance of counsel claims that the defendant now raises were raised in the motion for new trial. Counsel's answer was they were not, or that it was primarily about the Martin hearing. That's incorrect. These ineffective assistance of counsel claims were raised. They were addressed by Judge Locke. He considered them specifically. He considered whether Larissa Andujar was competent to testify. He found her competent. He considered whether a motion to suppress her identification would have been allowed. It would not have been, he determined. He considered whether counsel was ineffective for failing to demand a voir dire of this juror, whose only basis for the alleged partiality was speculation by other jurors. He found that it was inappropriate to have inquired further into the juror's thought process. Similarly, with the expected experts, there's no affidavit from those experts. Judge Locke specifically addressed counsel's performance and found that counsel's performance was not lacking in any respect. It's all in Judge Locke's findings on the motion for new trial. He addressed every single one. The only one he didn't address is the one that defense counsel raises for the first time here today at oral argument, that counsel was ineffective as to the Martin hearing. Search high and low in the defendant's brief, and you won't find any claim of ineffective assistance of counsel as it pertains to the Martin hearing. It only is addressed in claims that Judge Locke failed to abide by the standards for conducting a Martin hearing and failed in making a determination that Mr. Herrera's invocation of the Fifth Amendment was valid. Those two claims are made in the brief. However, they were also made at the motion for new trial, and Judge Locke found specifically that there was no error.
Could you walk me through this, what I thought started out as an immunity hearing and turned into a Martin hearing?
Yes, Your Honor, of course. A few days before trial, on January 16th of 2004, the Commonwealth and the defense met for a normal pretrial hearing, normal matters to be discussed on the eve of trial. One of the issues raised, there was a habeas issued to Mr. Herrera, who was being held at the Suffolk County House of Correction. He was potentially a Commonwealth witness, as Judge Locke found specifically. He had given a statement to police, and he was identified by the main eyewitness in this case, Larissa Andujar, the other victim, as having been on the top of the staircase where the defendant fired.
What did his statement say?
His statement is not in the record, so I can't say exactly what it was, Your Honor.
Did defense counsel have it?
Yes, it was provided in discovery. That there was no claim as to a deficiency in discovery. What I will say, however, is that all the parties had that police report available to them. There was a written statement made. It was available. However, because it's not in the record here, I can't tell you exactly what he said. From inferences from the transcript, from what we do have available from the record, is that defense counsel at trial viewed Mr. Herrera as a potentially devastating witness, as the court has pointed out. Furthermore, he was viewed as present at the time and location of the shooting, and given that he had admitted to drugs, to possession of drugs at the time, had open drug cases, had an open gun case, there was no question. It was blatantly obvious, even from the open court portion of the proceedings, that Mr. Herrera had a valid Fifth Amendment privilege not to testify. Judge Locke specifically considered the fact, in the motion for new trial, he specifically considered the fact that a Martin hearing probably wasn't even necessary in this case. But he didn't have the benefit of Pixley. He didn't have the benefit of everything that has since come forward.
So it started with the Commonwealth
Yes.
pressing to see whether he had a valid claim of...
Correct.
for
And
purposes
there
of
had been
immunity.
no effort to contact the other offices of the district attorneys around the state or the Attorney General's office at that point on January 16th. So in that case, this matter was brought forward. Mr. Herrera was available, and though Mr. Shields, Mr. Herrera's attorney, objected to holding the 20E hearing at that date, Judge Locke said, well, at least today I can determine whether the Fifth Amendment privilege is valid. So this hearing was in anticipation of the 20E hearing. And in this case, Your Honor, the only issue really, and it's right in the record, Judge Locke was only considering the validity of Mr. Herrera's privilege. He did so enough to establish that there was at least a possibility. It was not perfectly clear that Mr. Herrera could not have incriminated himself. And so the standard was met. That appears to be, from a reading of the case law, the only basis for a defendant to challenge a witness's invocation of the privilege, is that the the finding of the privilege itself was somehow invalid or arbitrary. The privilege here, as Judge Locke found and as the record backs up, this privilege was substantiated. There was no error in the finding itself. As to whether his attorney was excluded, his attorney did object, but he has no standing to be in that hearing. Judge Locke's exclusion of the defendant and defense counsel from that hearing was correct. There's no error, furthermore, despite all of what's said here on appeal, what exactly should have been revealed to the defendant that wasn't revealed. We now have the transcript. We can now look, even though it was released, again, without the benefit of Pixley, this transcript was made available, and still we don't know what could possibly have helped the defendant, which occurred at that hearing.
So I understand that the Commonwealth, the prosecutor, would be present if it's starting as is there a valid privilege as in anticipation of a 20E hearing.
That's correct. And virtually, sorry, Your Honor.
When it morphed into a Martin hearing, technically the prosecutor should not have been part of that, correct?
Well, I don't think that in this case, ADA Moriarty's presence in the hearing was improper. It's Judge Locke found specifically that his presence there was to raise any contest, to contest the validity of the claim of privilege. Judge Locke looked at Mr. Moriarty, and virtually the only thing that Mr. Moriarty did during the hearing was to say that he did not contest this invocation. So in this case, Your Honor, because this was in anticipation of an immunity application, I think it's proper that the prosecutor was present for this portion of the hearing. Moreover, as Judge Locke found, there was nothing of substance revealed during this hearing that wasn't already revealed in open court. So there was no danger to Mr. Herrera. And in any case, he had counsel. He had counsel appointed to him who could have objected if they felt that they were reaching areas where the prosecutor shouldn't be.
Whatever became of the immunity question?
The Commonwealth ultimately decided not to seek immunity.
And that was that day or thereafter?
I don't believe it was decided on the record that day, Your Honor, but ultimately when the Commonwealth
Didn't request in a hearing regarding it or anything?
No hearing was requested, no hearing was conducted, and the Commonwealth never attempted to call Mr. Herrera to the stand.
And unless I missed it, I gather that there was never any part of the hearing in which Mr. Herrera told the judge information that would otherwise be within the scope of a privilege.
Yes, and in fact, there was essentially nothing revealed. All that was talked about was what had already been revealed in open court.
About the pending charges.
About the pending charges and about the fact that Mr. Herrera's statement, the one thing we do know about Mr. Herrera's statement to police is that he admitted to having drugs. He had an open drug case. And in this case, the theory was that the evidence suggested that Mr. Alicea lured the two victims to the scene of the shooting with drugs to get them to come there so he could exact revenge for a robbery that had taken place at his sister's apartment. Given those facts, defense counsel had every incentive to ask Mr. Herrera whether he was the one who possessed the drugs to lure the two victims there. So at the very least, the defendant's own, or excuse me, Mr. Herrera's own admission in his statement that he was in possession of drugs, that was going to incriminate him. So there's absolutely no question that this was a valid invocation of the privilege. I'd like to address very briefly ineffective assistance. I touched on it before. As I said, Judge Locke made specific findings on every single one of the ineffective assistance claims raised here, with the exception of that new ineffective assistance claim as to Martin. I'd just like to clarify a few matters. Judge Locke found that defense counsel conducted what he called a particularly effective cross-examination of Joan Cannon, one of the EMTs called in this case. The other EMT was the sole witness called by the defendant, and the defendant did in fact call that expert as an expert on the uses and addiction of heroin, the effects on someone's ability to perceive and recall. So in this case, the defendant's claim that no heroin expert was ever called is simply false. In addition...
The defendant called the
expert?
expert?
The only witness, this is Deanne Dennison, the final witness called in the entire case, was the sole witness called by the defendant. Deanne Dennison was another paramedic, the second paramedic after Ms. Cannon, and Ms. Dennison was called on, this is from page 57, volume 4 of the transcript, was the final witness and the only one called by the defendant, and defendant's questions focused on the effects of heroin. And so in this case, The heroin expert, the alleged heroin expert that's now claimed it was essential, that testimony was already received through an effective cross-examination of Joan Cannon, the first EMT, and
She the
through
one that
direct
gave
examination.
the test?
The Glasgow coma scale
And
was
he asked her about the tracks?
the existence of track marks, whether she noticed that there were track marks, and whether a person who had ingested heroin, as Ms. Andujar had admitted she had, whether such a person could ever score a 15 out of 15 on the coma scale. Ms. Cannon acknowledged on cross-examination that no one could, and thus undermined her own testimony. That was why that cross-examination was particularly effective. The defendant doesn't tell us what his alleged imaginary expert could have told us in addition, and in this case, Your Honors, there's absolutely no reason to grant that the defendant was subject to ineffective assistance of counsel falling below the standards of an ordinary fallible lawyer. So in this case, Your Honors, unless there's questions as to
Let me turn to extreme atrocity
Yes,
and
Your Honor.
cruelty. Number of gunshots. I
Yes.
guess some reason to think that one of the shots hit him in the arm
Yes.
before he was shot in the head. Do we have any evidence in the record as to how quickly the gunshot to his head would have killed him?
There's no evidence in the record as to that. The evidence is that he lost consciousness, or at least was not rousable by Ms. Andujar shortly after being struck in the head by that final blow. But I think the key to the to the extreme atrocity or cruelty claim at this point is that multiple gunshots were fired and hit him prior to the final blow. The defendant seems to indicate in his brief that he believes that the final blow was the only gunshot
Well,
struck
let
to
me
his
ask you a
head.
question about that, because as I understand it from the defendant's brief, the shot to the head, which was the fatal shot,
Yes.
went from front to back. Is that right?
I believe that's correct, yes, Your Honor.
So if I have the facts straight, the two of them are coming up the stairs. I'm assuming that from where these shots were, that the shot to whichever arm it was that was in the front to back was when they was still facing the building, and then was running. So I'm not clear. It seems to me that there is some grounds to say that it was not the last shot, because I don't see he was running the other direction.
I'll say I'm confused as well, Your Honor. What was happening was the steps that leading up to this balcony where the shooting took place were crossing steps. They were the first set of stairs would go one direction and the opposite would go the other direction. The defendant was on the third level of these steps, and the shooting began when the two victims were on the second level of the two steps. And Mr. Hyla Strange, the murder victim, was ahead of Miss Andujar and ascending the stairs when the shots rang out. Miss Andujar's testimony is that as the shots began to fire, they began to understandably flee the shots, and Mr. Strange jumped back off of the stairs in reverse, trying to escape, made contact with her,
Pushed her
out of the way. They pushed her into an alcove, and as they tried to escape going back down these crossing stairs, he was hit multiple times. She says when he reached the final level where he eventually landed and died, he took one additional step, and then the shot hit him in the top of the head, and that's when he fell, and that was the final blow. And the autopsy revealed that the final blow was was the cause of death. So in this case, Your Honor, I think it's fair to say that Ms. Andujar's testimony established that the multiple gunshots occurred first, one to his left upper arm, one to his right upper arm, and one to his hand, and then the final blow was struck.
Well, let me ask those questions in a slightly different way. Was there any indication from the testimony that he could have been shot in the head first and then engaged in all these defensive maneuvers?
There's no indication from the testimony of that, no, Your Honor.
And the medical examiner, well, you said this. There's no evidence that you would die instantaneously from the shot to the head?
There's no evidence one way or the other. All we know is that Ms. Andujar saw the final shot.
She saw that it hit his head?
She didn't testify as to whether it hit his head, but she testified that the last shot was the one that felled him, and the final shot was the only one that was a fatal shot. The other three were one to his shoulder, one to his other shoulder, one to his hand, and the autopsy cited the final, well, not the final in sequence, but the headshot as the only one to cause death.
But couldn't the defendant have legitimately argued that, well, yeah, no, he was shot in the head first, and it would have taken several seconds for him to lose consciousness, so within those several seconds, he could have engaged in all these defensive maneuvers?
Yes, it's true. In that case, however, the defendant continued firing at him and continued hitting him, in which case
it still is...
In which case, it's still extreme atrocity or cruelty to sustain the verdict, because he was then firing multiple wounds at someone who was already fatally struck but not yet deceased.
Was deliberate premeditation offered?
It was charged. It was argued by the prosecution, but the jury returned a verdict only on extreme atrocity or cruelty, to my surprise.
Is there a photograph of these crossing stairs in the record?
There were multiple photographs entered at trial. I don't believe any are in the appellate record as it stands. However, they are in
But
the
they're part of the
yes, they are
exhibits.
exhibits and would be available in the clerk's file.
Are these stairs sort of like, not an arced spiral, but like square-edged spiral stairs?
Yes, they are. I'm not sure how many, but
Series
like,
of right angles that go down gradually.
correct. Eight followed by a landing, followed by a turn. 180 degrees, followed by more, going up to 3 levels. Yes, Your Honor. So in this case, Your Honor, unless there are further questions on extreme atrocity or cruelty or any other issue, the Commonwealth would rest on its brief.
Thank you, sir.
Thank you.